Yes, Mr. Bates.
Thank you, my lord. My lords, you kindly allowed me 5 minutes just to finish on the right to buy and the development of the policy. Hopefully I can do it even quicker than that, because I can steal from what Lord Justice Brooks said in Payne and Barnett, where he summarises it all for us. If we go to tab 2 of the authorities, page 27, you see there the italicised normal, ordinary and making good structural defects. He's describing there the 1980 Act as enacted. And you see that in relation to structural defects, you didn't have to say anything about them, but if you wanted to pass on the cost of making good structural defects that you've been aware of at any time earlier than 10 years after the lease was granted, you could only require the tenant to bear a reasonable part of the costs if you'd given them notice informing them of the existence of the defects and the estimate of the amount which they would be liable to pay towards the cost of making them good. That's then completely changed, following on down, by the Housing and Planning Act 1986, where Parliament changes the scheme. And just jumping through the provisions over the page, paragraph starting the 1986 Act explains the new way of dealing with it. And the way the legislation works is summarised in that paragraph and then again under the italicised headings. Making good structural defects at the bottom of the page, you have to give a description of any structural defect known to the landlord affecting the dwelling house, but subject to this, the landlord's ability to recover any part of the expenses he incurs making good during the reference period is governed by the same principles as ordinary repairs. So jump back a page, ordinary repairs, you have to have itemised what you're going to charge and the likely cost or an annual amount, and then there's an inflationary index for 5 years. So the way it worked originally was you had quite a significant restriction, more akin to how the carve-out looks nowadays. And then post-1986, you get the 5-year transition window. The 125 notice tells you about any structural defects, but most importantly, it tells you what you're going to be charged for the next 5 years, and subject only to inflation increases, that's the maximum you can charge. But after year 5, it's a normal lease. That's the policy of the right to buy legislation. That's all I wanted to finish on. Thank you.
Thank you very much. Ms. Gibbons.
Lords. I was going to deal with the time available to me to deal with the matter in this way, starting briefly with the facts, and I will be brief. As delightful as it is to hear Mr. Bates's account of the history of these buildings for the third time, we say a lot of that detail isn't necessarily relevant, so I'll be fairly brief on that. I'll move on to contractual interpretation in general. That again I can take fairly briefly because there's not a lot between us in relation to that. I was then going to move on to the interpretation of sweeper clauses or clauses of a type that 550 is, and then deal with the points in the respondent's notice. However, I think having heard how things have gone this morning, it might be better to start with the issues that arise from the respondent's notice, which is the legislative background against which these leases were drafted, and against what we say that the context in which these leases fall to be interpreted. So I think it's perhaps better to start with that, and then we can look at the interpretation of clause 5 and clause 550 and paragraph 11 in that context. So if you'll permit me to slightly take out of order, given that it is a point in the respondent's notice rather than on the appeal itself.
Yes, that's fine.
So starting with the facts, and just a slight word of caution, it was the First Tier Tribunal that had before them 2 expert reports, witness statements from Tower Hamlets in terms of the history and the various surveys that have been carried out at different times. And on the basis of that, the First Tier Tribunal set out the history, paragraphs 8 to 17 of their decision, and that begins at, and you'll forgive me, I hadn't appreciated that the numbering was slightly out in the core bundle as between the electronic bundle and the hard copy. I was relying on the basis that bundles have been prepared in accordance with the guidance. So I have electronic numbers. I think it's 1 page out, and I was trying to work out this morning exactly where. But to start with, the FTT decision and their history begins. I've got a note at page 71 of the core bundle. As I say, I'm not going to go through that, but I just reference that because the appellant applied for permission to appeal, and it applied for permission to appeal insofar as the First Tier Tribunal's account differed from its own. And they were refused permission to appeal on that basis. So when we got to the Upper Tribunal weren't considering itself any of the evidence, any of the witness evidence or any of the expert evidence. What the Upper Tribunal had before it was the FTT's account and the account that you've heard from Mr. Bates by way of submission. So just as a note of caution in terms of any reciting of that account, that insofar as there's a conflict between what the Upper Tribunal say and the First Tier Tribunal say, it was the First Tier Tribunal that had the evidence. There wasn't a great deal, I think, that necessarily came out as being material in terms of anything that Mr. Bates said that might be inaccurate, but there was just one point of clarification, and that was the question about the standards against which the building was being measured. And Mr. Bates took you in the supplemental bundle to page, first of all, page 780. And this was the reference to the Building Research Establishment Handbook, LPS Handbook of 2012. And what that said, it was paragraph 7. The BRE's LPS handbook has provided a change in the understanding of how these buildings are assessed and behave under accidental loading. So it wasn't the guide, the standard that had changed, it was the method of assessing these buildings as against that standard. And that's repeated in the expert evidence that Mr. Bates referred you to at page 801 of the supplemental bundle. That was Mr. Voizilla. And under the heading BRE Guidance on Assessing LPS Blocks, in 2012, BRE published the Handbook for Structural Appraisal of Large Panel System Dwelling Blocks for Accidental Loads. This document was written in order to update the government's 1968 guidance to consider all of BRE's subsequent research, the general development of assessment methodologies, so that in terms of the standard with which they're being assessed, and that's set out at the bottom of that paragraph, the document continues to recommend that LPS blocks with pipe gas should be assessed against their ability to withstand a pressure of 34 kPa. However, if pipe gas is not present, this figure is reduced to 17 kPa. And those are the figures that appear throughout the previous reports that Mr. Bates referred you to. And he did refer to the halving of the appropriate standard if there was no piped gas. I haven't made a note of all of the where all of the various reports appear in the bundle, but I did extract in the statement of case for the First Tier Tribunal the page 16 of the supplemental bundle. Under the heading Defect History, starting at paragraph 14, setting out the first of the reports that we relied on, and looking at the various reports which all refer to those figures of 17 and 34. So, and it was certainly the respondents' expert evidence before the First Tier Tribunal that it wasn't the standard that had changed over time, it was the method of assessing whether or not the building met that standard which had been developed. The other point in terms of the facts as set out by Mr. Bates, he referred you to the cost and he referred you to the Section 20 notices. They were, of course, issued some time ago. He referred you to the supplemental bundle, page 559, which set out the original estimated costs. And obviously originally we have the figure of just over 8 million, and the amount estimated for this particular leaseholder was just over 73,000. That's because this estimate relates to a 2-bed flat, and there are different estimates depending on it's 1-bed, 2-bed or 3-bed. That estimate has since increased. Before the Upper Tribunal, there was a letter from Tower Hamlets dated the 23rd of November of 2022. That set out that at that point the total cost had risen to £9,297,273.19 to be precise, and that in rough terms that meant for 1-bedroom flats the service charge was likely to be just over 70,000, for 2-bedroom just over 84,000, and for 3-bedroom in the order of £94,500. So fairly substantial sums when we're looking at ex-local authority flats in a high-rise building. That was just dealing with a few points in terms of the facts that were set out by Mr. Bates, but really it's crucial to bear in mind that in terms of the work is to address an inherent defect. And it's the inherent defect is the method of construction used in LPS buildings. And that construction was always known to be problematic. In fact, the appellants accept that in their skeleton argument. They say at paragraph 13 of that skeleton argument, they refer to the fact that these there was the problems with LPS became clear fairly early on following the Ronan Point disaster. Yes, they refer to the fact that in 1968, the housing sector and the UK more generally became aware of significant flaws with the LPS model. They reference, in terms of Ronan Point, Wikipedia, and they set out there the effect of the Griffiths inquiry into Ronan Point. I can take you to that. Which is in the supplemental bundle, 180. Begins at 179.
Supplemental 180.
Yes, that is the reference I have.
I have a sideways.
Oh, yes, so have I. I don't know what's happened there. I'll come back to that one. It was actually the reference, what, sorry?
479.
Oh, 479. I'm missing a digit, sorry. Yes, so at 479 we have the picture of Ronan Point and the Wikipedia entry setting out what had happened there. And then over the page at 480, the Griffiths inquiry. And at the bottom of that page at 480, it talks about Sam Webb, the architect, who gave evidence to the Griffiths inquiry, and he predicted that after approximately 15 years, Ronan Point would develop structural problems and collapse. Webb's concerns eventually led the council to evacuate the building and then demolish it in 1986 in a forensic manner rather than, for example, using explosives. When this was done, the extent of the defects found shocked even some of the activists, including Webb himself. On the lower floors, cracks were found in the concrete where it had been point loaded, and it was alleged that the extra pressure on those points during high wind, such as during the Great Storm of 1987, barely a year after demolition, would soon have led the building to collapse. And that this was also something that was recognised, we say, by Tower Hamlets when they actually looked at doing the works that we're now considering. So that the notes to Cabinet that were referred to in the statement of case, and they appear at page 301 of the supplemental bundle. And you'll see this is a report to Cabinet dated the 26th of June 2019. And at page 303 of that report, paragraph 2.2, the works are required as a result of a safety consideration that became apparent after the blocks were built, the Ronan Point explosion in 1968. They go on to say responsibility for repairs fall upon the owners, which includes leaseholders. That doesn't seem to be a particularly thought through comment. So that was, in terms of the work, that's what led to the conclusion that the FTT drew, and has already been referred to by your lordships, the FTT's conclusion, where it says in its decision, and that the reference you mentioned earlier at paragraph 54, which is, I've got it as 83 in the core bundle. And that, say, my Lord Snowden referred to it earlier. The fact is that LPS had a defective design. That defect was there at the start and still exists. Since it first arose, more has been learnt about it and further remedies have been devised. However, that knowledge and those remedies relate to the same defect. So against that background, the works that are now proposed are extensive. The work was set out in the FTT's decision at paragraph 74, at page 74, which is summarised, as Mr. Bates said he wasn't going to take to the full specification, and neither will I. But the works include the installation of an external steel frame, the application of external reinforcement across walls, installation of internal bedroom steel frames, installation of lobby cupboard steel frames, and the associated works. So what is in effect being done is to create, short of knocking this building down and rebuilding it to modern standards, what is being created is really a new thing. It is a building that is no longer an LPS constructed building, relying as it does on the walls for support. It is creating an external steel frame and these internal boxes to create the support. So it is, as we say, it is creating something different in nature rather than necessarily making the existing building doing work to make it safe. As Mr. Bates has said, the applicants originally put their case that this work fell within the covenant to maintain and keep in good condition. That was dismissed by the Upper Tribunal, and that was dismissed if we look at paragraphs 44 and 46, which appear in the core bundle, electronic number, page 50. And referring there to asset hold, which Mr. Bates took you to, asset hold is as unhelpful as the rest. What was argued there, and in this context, the judge was referring to maintenance, which was an issue in asset hold in addition to the sweeper. What was argued there was that maintenance was the preservation of the subject matter of the covenant in its original state. And at paragraph 49, the Deputy President said that to maintain involves preserving a functional condition by acts of maintenance performed on or to the thing to be maintained. The emphases are mine. To preserve is not to make something new or to make something safe that was not safe. She goes on at 46, neither a covenant to repair nor a covenant to maintain is a covenant to remedy structural defects, nor to make safe a building that was not safe when it was built. So there, the argument about maintenance failed because it was accepted that what was being done was to return a building that was different to that which was there before. And as Mr. Bates accepts, there has been no appeal against that finding to this court. I will just add in there, I wasn't necessarily going to, but it became apparent.
Where do you draw the line between works which create something new and different from what was there before, and those which don't?
Well,
is that an important part of your case?
It's probably not, in the sense that our argument is that if you are remedying a structural defect, and when I come on to what the Housing Acts say about that, you'll see how the Housing Acts categorise that. So it's not strictly because we say any structural defect that does not arise that is not repaired by way of a repair. That is excluded from the provisions of these leases. So it doesn't necessarily matter. I simply emphasise the point because this shows the limits of what could be included in a covenant of this nature, if it is that the nature of work to remedy a structural defect is included. Rather like, think if you were to look at, what was happening in Dell, and you were to look at these, if you were to say to someone signing up to a lease, you are potentially going to be liable for a lengthy dispute with a renowned architect about building a glass cube and 2 subterranean levels underneath. Now, that's the specifics, but the point is that's pushing the nature of those costs to its limit in terms of which, if those sorts of costs were included in the service charge, it can extend to those sorts of limits. That's not about saying, and so that goes back to the quantum point, which is not that it's the quantum that's appointment, but for those sorts of costs, they could extend to really large sums of money and really types of things that the leaseholders would never have agreed to sign up to. And so that's simply the point that I'm making here, that once you start to bring inherent defects and the liability to make good, which is the language of the Housing Acts is to make good structural defects, when you bring that within the clause, it opens it up to works such as this, which are incredibly extensive in nature and, as I say, stop short of pulling the building down. But that is not to say there's necessarily a line at which you'd say, well, works up to this level are okay, but anything more is not. I mean, what is said in Dell, in effect, that sorts of safety features that 550 is intended to capture are things like fire extinguishers. I mean, you can imagine, especially in the sort of wake of Grenfell, that, we might have to have retrofitting of sprinkler systems to make the building safe. It's those sorts of things. And it's said in Dell, there isn't a bright line. It is for courts to work out which side of the line things fall, but it is very much the tenor of the cases. It is those sorts of things, fire extinguishers, carbon monoxide detectors, sprinkler systems, those sorts of works to an existing building to make it safe, as opposed to...
Fall within O. They'd fall within L.
Well, yes, I mean, on the specifics of this lease, there is provision, but talking about in the future what sort of things there might be, that was an example given by in Dell, and I appreciate it was by reference to the existing lease clauses, but it was talking about that as an example of a type of safety feature.
Yeah, I mean, you're just saying you construe O in the overall structure of the clause in which it is found, following on from, a number of other types of expense.
Yes.
As it happens, one of those other types of expense is fire extinguishers and the like. There's communal aerials, there's electric plants, there's entry phone systems. And you're really just saying construe the clause in the environment in which it is placed.
Yes,
you wouldn't expect it to include essentially constructing something which is a fundamentally different building.
Yes. But as I say, where I think it's difficult to say, as it said in Dell, it's difficult to draw a line as to exactly where that comes. But we would say for reasons that I'll go on to, we say remedying a structural defect cannot have been intended to be part of this lease, given the statutory background against which the lease was drafted. But as I say, in terms of my Lord Miles's question about where to draw the line, in this case we say it's about the nature of the work, which is to remedy a structural defect. But overall, in terms of where the line falls, is not necessarily an easy one to draw in terms of types of work that might be within the clause.
Not everything that could be labelled or have an ingredient associated with safety on your submission falls within 550?
No, no. That would be, well, I'll come on to a very literal interpretation of the particular clause, and that is not, we say, what Arnold and Britton says. It is still about contractual interpretation and looking at the clause in the context of the lease as a whole, looking at its purpose, looking at the factual matrix, etc., which I'll come on to in a moment. Just going to these leases, because I think what became obvious had not been made clear, was that we have, as set out in the applicant's statement of case for the First Tier Tribunal, there are actually 32 long leases within these two blocks, which together comprise 112 flats. That was when the statement of case was drafted. I'm assuming, I could be wrong, that no one has sought to exercise the right to buy in that time, given everything else that's been going on. But as at the date of the statement of case, there were 32 long leases. 9 claimants have been named, original applicants to the FTT application, which provide a sample of leaseholders and leases. And those leases are helpfully set out in the appellant's skeleton argument at electronic page 22 of the core bundle, and it's paragraph 20. And in relation to these leases, the first two, 1989 and 1990, have the carve out that you were discussing this morning. So they start in chronological order. The leases start with the carve out. And when we get to the lease of 1985, that carve out is removed. Now, I appreciate there was 1995.
You said 85.
Oh, sorry. Sorry. So when we get to 1995, the carve out is removed. And so the later leases do not have that carve out. Now, there was some discussion this morning about how we interpret leases by reference to each other. What I would say is that these are standard form right to buy leases used by the London Borough of Tower Hamlets across its housing stock when leaseholders exercise the right to buy. So that they start off drafted in a particular way which reflects, and it in fact, I will say, it doesn't reflect the law as it was in 1989, because as Mr. Bates says, there was a change in the law by the Housing and Planning Act 1986. That came into effect on the 1st of January 1987, and so all of these leases were granted after that. But for reasons I'll come on to in dealing with the points in the respondent's notice, we say that these first two leases are very much drafted against the backdrop of the Housing Act 1985 unamended. So that is the starting point, we say, in terms of interpretation. And we say that the statutory background for the 1985 Act informs how those leases should be interpreted. And that then the fact that that carve out is omitted in the later leases, we say should not affect the interpretation of the remainder of those leases, because removing of the carve out, it's not, for example, removing a word not that would change the meaning of the clause. It just removes the carve out.
Well, I mean, there were two propositions I was attempting, I think, to put to Mr. Bates, probably badly, but you can't construe the first two leases with the knowledge of the post-1995 leases. I mean, that's sort of contract construction lesson 1. The more interesting question is whether you could construe the later leases in light of changes that were made to other leases in the same building without any evidence that suggested that somebody entering into a lease in 1995, say, wouldn't have as part of the matrix of fact that there had been earlier leases which included different provisions. And presumably there's no findings of fact about that matrix at all.
No, and I wouldn't put it in that way. What I would say is we are in construing these leases against the matrix of fact, which is the Housing Act scheme, the Housing Act 1980, then the Housing Act 1985, amendments brought into that, and then we've got, as I say, the Housing and Planning Act. So when construing against that statutory scheme, the factual background, I think we can take into account that the lease of 1995, in all but that carve-out, was drafted against the background of the Housing Act 1985. So the rest of the lease, and if we look at it in that order as to why it is, I say, looking at those first leases, we can see that they've been drafted against. I mean, there's still arguments in relation to 1985 that are relevant, but I say we can look, not because people would have been aware that there are other leases in the building that say it, but looking at what the draftsman had in mind in terms of these leases, we can say that the draftsman had in mind the provisions of the 85 Act, and what happened in 1995 was that simply what got omitted in an updating of the leases was a carve-out that was no longer relevant. And so that shouldn't affect the interpretation of the remainder of the leases, but the factual background is not the other leases in the building, it still remains the legislative history. So that is how I'll put it, and I'll come on to those right to buy provisions. But as I say, but also to point out, as I say, these are standard form, and in fact we have an example within the authorities bundle in One Housing and Kingham, where in that case what was being considered was that's a case that appears at page 49 of the authorities bundle, and the relevant paragraph there is paragraph 2 in the introduction at page 51. And what is said is, in the course of its decision, the LVT was required to interpret the standard form of lease used since the 1980s by the appellant's predecessor as landlord of Spinnaker House, the London Borough of Tower Hamlets, when granting long leases to its secure tenants under the statutory right to buy regime of the Housing Acts 1980 and 1985. And that's just by way of example. I'll come on to what's the considerations.
I understand why you say that you interpret a lease against the current statutory background in existence at the time of the lease.
Well, actually, that's not what I'm saying, with respect, my lord. And I will come on to explain that, because that is very much what one would assume. But when one looks at these leases, as I said at the outset, the law changed in 1987, but the manner in which these leases are drafted suggests they were drafted to comply with the unamended 1985 Act. And I'll bring you to...
Sorry, with that...
Yeah.
Sorry, you're absolutely right. You did say that you were going to be saying that the statutory scheme that was followed was one that was pre-amendment.
Yes.
But I'm struggling to understand at the moment what the significance is to be attached to the fact that these are in a form which is in widespread use in Tower Hamlets.
I was simply making the example that when we're looking at the leases, as I say, it's a standard, it doesn't change. So the form is used throughout. I mean, obviously, what was being referred to in Kingham was the sort of geographical spread of the leases. What I was talking about was the chronological spread of the leases, that the underlying form of lease doesn't change from that which was originally there. It is a standard form lease. It was just more by way of an aside that it's a standard form, but we'll come on to the detail if you'll bear with me, because at this point, I think I slightly lost the judge in the Upper Tribunal, and I will endeavour to be careful and do better this time. But that's where I said that the judge in the Upper Tribunal slipped up in saying that the right to buy wasn't relevant, because what the judge fixated on was how did the legislation apply to these leases as at today or as at the date they were granted, and we weren't saying that they were those acts were restricting the ability now to recover service charges. And I'll take you through Great Arthur House, if I may, in due course, because that provides a very good example of this court applying that approach to right to buy leases. So, as I say, I simply, in terms of the facts, that I just wanted to make clear, because we seem to be a little bit confused as to which leases had which in. But that helpful table sets out the leases in date order. We've got examples of 2 of them, but as I say, it's those first 2 that have the carve out, and the rest do not. So coming on then to the general principles of contractual interpretation, and I take no issue with Arnold and Britton in principle. Mr. Bates relied on it both in the First Tier Tribunal and the Upper Tribunal, and as he does before you, as meaning that a literal approach to construction should be adopted, and that is in effect what his submissions amount to. This clause says that anything can be done for the safety of these buildings. These are works of safety, therefore they fall within this clause. And that is in sum the argument. And on first flush, Arnold can seem to be an example of a literal, well, it is an example of a literal interpretation, but that's not setting a principle of interpretation. Obviously, you've got Lord Neuberger's 7 factors to be taken into account. But as Mr. Bates highlighted, the clause in Arnold had dire consequences for the tenants of the holiday chalets in the Gower, and seemed an unlikely result. But in that case, the clause that permitted the landlord to charge a fixed service charge, increasing by a certain method, was both clear and it was specific. So that it was very difficult in Arnold to interpret that clause as meaning anything different without a rewriting of the clause, without finding that something had gone wrong in the syntax, so that it was looking at an intention of the parties that was not evident in the clause itself, but which was on the basis of, well, in hindsight, they would never really agree to this. That wasn't looking at what they would have intended as at the date of the lease. So Arnold is not, we say, authority for taking a literal approach to construction, and that was confirmed by the Supreme Court in Wood and Capita, and that was the clause that the case that, unfortunately didn't make it into the authorities bundle, but it was referred to by both the First Tier Tribunal and the Upper Tribunal. And the relevant passages there, and it is only confirming Arnold, it's not saying anything different, but the relevant passages in that little supplemental bundle are at page 8, and they are at paragraph 9 and paragraph 10. And then halfway down paragraph 9, but it may assist if I explain briefly why I do not accept the proposition that the Arnold case involved a recalibration of the approach summarised in the Rainy Sky case. The court's task is to ascertain the objective meaning of the language which the parties have chosen to express their agreement. It has long been accepted that this is not a literalist exercise focused solely on parsing of the wording of the particular clause, but that the court must consider the contract as a whole, and depending on the nature, formality and quality of the drafting of the contract, give more or less weight to elements of the wider context in reaching its view as to that objective meaning. So that's simply confirming or clarifying that Arnold wasn't about a literalist approach. It's what we say and what the FTT and Upper Tribunal said. And the references to those decisions in the First Tier Tribunal, it was at paragraph 41, page 80 of the core bundle, and in the Upper Tribunal at paragraph 51, at page 51 of the core bundle. So touching briefly on what was said in Dell, Dell didn't refer to Wood and Capita, that Dell, but does refer to Arnold and Britton, and that is dealt with at paragraph 18 at page 168 of the authorities bundle. and you've got there Lady Justice Falk referring to Arnold and Britton, referring to Lord Newburger's 7 factors, and she elaborates on paragraph 21, the 7th point. The 7th point is specific to service charges, and she says, quoting Lord Newburger, "Seventhly, reference was made in argument to service charge clauses being construed restrictively." At the bottom of that page, the origin of the adverb was in a judgment of Ricks, LJ, and McHale and Cadogan. And then she goes on at 22 to say there appears to be an element of tension between the principle that service charge clauses are not subject to any special rule of interpretation and Lord Newburger's approval of Lord Justice Ricks's statement in McHale and Earl Cadogan. However, I consider that this is a more apparent than real. It must be borne in mind that leases are typically long-term obligations with the potential for significant future liabilities. It is inherently unlikely that the parties entering into such a transaction would intend to commit themselves to obligations that are neither expressly spelled out nor of a nature that clearly fall within the general words read in their context. So that is an application of those principles in Arnold and Britton to service charge provisions. So with those general factors as to statutory interpretation, I'll come to the points that arise out of the respondent's notice. And this is the appeal against paragraphs 27 and 28 of Judge Cook's decision in the Upper Tribunal, which those paragraphs appear at page 47 of the core bundle. She sets out very briefly at 27, the right to buy legislation has been amended, etc. We take no issue with that. Then she says all the respondents' leases were granted after that date. That means that all were subject to restrictions only as to the level of service charges for the first 5 years, etc. Accordingly, none of the statutory provisions in the right to buy regime has any effect now upon the extent to which the service charges imposed by the leases are recoverable, and I do not need to look further at that legislation. And I am not assisted by the decisions of the Tribunal or the Court of Appeal in Great Arthur House, which were about leases where the landlord was to make good structural defects. So those were the 2 short paragraphs dismissing any reference to the right to buy legislation. Now, we say that the right to buy legislation is relevant in 2 respects, in that it is relevant in construing these leases to look at the legislative background, i.e. the statutory framework with which the leases were drafted to comply. So that is looking at the details of the legislation, the historic legislation. And then secondly, the statutory purpose, and that's something that can be dealt with relatively quickly, but it's about what was the purpose behind the right to buy legislation, and is slapping leaseholders with very high bills for service charges within that statutory purpose or in conflict with that statutory purpose, and we say it is. But as I say, starting with the legislative background against which the leases are to be construed, starting the fact that right to buy is a relevant consideration, we have numerous examples in the case law where it has been applied. And in the authorities, you were taken by Mr. Bates to Brenton Hamilton. That is in the authorities bundle at page 40. And paragraph 12 on page 45. What is said there in the second sentence, it's also reinforced by the consideration of the context in which clauses in the lease were drafted. The lease in this case was made under the right to buy provisions. So it was relevant to consider, and Mr. Bates picks up on the fact that that in that context, the council's costs ought to be recoverable. Now, it's important to bear in mind that in Hamilton, the issue was management charges. So the dispute was over the tenants being liable to pay for certain management charges that Brent had added to the costs of services. But the point was made by the Deputy President that if you're going to have a covenant to clean the windows, for example, somebody needs to book the window cleaner, pay the window cleaner, check the work possibly, and as a local authority can only act through its agents, there's going to be a cost to doing that. And so it was part and parcel of the costs of those services that fee for management should be included. So it was very much consistent with, if you'd have asked what would be included in a lease of this type, those sorts of costs clearly fell within it. But that, as I say, is simply an example of how looking at this through the prism of the right to buy legislation was considered to be relevant. I've also referred you to Kingham, One Housing in Kingham, which appears at page 49 of the authorities bundle. And as I say, that was in relation to Tower Hamlets leases, and so the lease was in a similar form or almost identical form to leases that we're considering here. If I take you to page 51, which we started at before, I'll move on. We've looked at that one. So if I can take to page 53, which at paragraph 16 refers to the lease of 29 Spinnaker House was granted 20th of June 1988 by the London Borough Tower Hamlets to the predecessor of the first respondent, is in the standard form used by the London Borough Tower Hamlets for right to buy lettings, term of 125 years, £10 a year. It was common ground that the lease was not a bespoke document drafted with the flats and maisonettes of Spinnaker House specifically in mind. And in terms of the issues in that house, in that case, the principal issue, or there were two issues, but the main one that's relevant for present purposes was whether or not the leaseholders should pay for a heating system, a district heating system. So there was a generator that was outside the building generating power for the central heating hot water, which then was supplying the individual buildings. And what the Deputy President said at paragraph 64, page 64, before addressing that question, it is relevant to consider the statutory context in which the lease was entered into, i.e. in pursuance of the statutory right to buy under the Housing Act 1985. And he goes on at paragraph 65 to say, the statutory implied covenant is a relevant part of the context or background against which subclause G of the LBTH standard form of lease should be construed. The parties entering into lease be taken to have in mind the statutory right to buy scheme and the borough's standard lease, which would have been drafted in the knowledge that it was required to conform with the relevant parts of Schedule 6 of the 1985 Act, including the implied obligations to maintain services at a reasonable level. The draftsman would have been aware that any gaps between his drafting and the statutory terms would be filled by the implication of the statutory term. One would therefore not expect to find any divergence between the statutory implied terms and the express terms of the lease. On the contrary, one would expect, and in this case it was 55G, because that dealt with heating, to impose the same obligations as that imposed by paragraph 14.2c of Schedule 6, and I'll come on to that in a moment. So the statutory implied covenants may therefore be a helpful reference point when trying to resolve any ambiguity in the meaning of the express covenants in the lease, including in particular 55G. And that is particularly relevant. I say, my Lord Mayles, you addressed the question about needing to remedy structural defects and the extent to which the local authority might not be obliged to do that. And as Mr. Bates pointed out to you, that there is an implied obligation to do that in any event. So that one was Kingham. And then moving on to Great Arthur House.
So where does that take us then? If there is an implied obligation in the legislation, does that mean that we would expect to find an express obligation in the contract, or what?
I'll come on to these. These were illustrative of simply the principle that the right to buy is relevant, because that was something that the judge didn't accept in the first instance. I'll come on to that, but the short point is there is an implied covenant to remedy structural defects. If there is an implied covenant to remedy structural defects, and the intention was that the leaseholders were intended to meet that cost, one would expect that to be spelt out in the lease. So the fact that the lease is silent...
In fact, you put it the other way around. I mean, if the statute says that the landlord has a covenant, or is implied, sorry, there is an implied covenant that the landlord has to make good any structural defects, you would not expect the cost of that to be passed on to the tenants, absent some indication.
Sorry, that was my lord. That was the point I was trying to make. So, yes.
Well, I was wondering about that, but there's also an implied covenant to do repairs and maintenance. Indeed, it's in the same provision, but
yes,
but that can be passed on
because that is expressed in the lease itself. So that the way the lease is structured, and I'll come on to this in a moment, but the lease is structured in terms of paragraph 5.5 sets out the work that the landlord is required to do, and then there is an obligation to pay for the work that the landlord is required to do. So 5.5 sets out that the landlord is obliged to repair and maintain, and that cost is therefore a cost that is recoverable because it is drafted into the lease as an express term rather than simply an implied term, so that in terms of the workings, the contractual machinery of the lease, it means those costs have to be paid for. Now, there is also the implied term to remedy a structural defect, and that also applies is set out in the same piece of legislation. But that has been treated in a different way by the draftsman in that it's the silence, so that it's made express in these terms of the lease that the implied covenant is made express, because then in terms of the contractual machinery, there's an obligation to meet the landlord's costs of complying with it. But as far as the implied term to make good structural defects, the lease is silent, which means there isn't obviously an obligation to pay for that. And so the very short point, which I was going to come on to in due course, but that if there is that implied obligation, one would have thought, and there was an intention that the leases should meet the costs of complying with it, one would have thought the draftsman would have put that in the same way that's been done as regard repairs and maintenance. So so coming on to the Upper Tribunal in Great Arthur House, this case, the City of London and the leaseholders of Great Arthur House, and it concerned whether or not the leaseholders of, I think it's blocks on the Golden Lane estate, were liable to pay for the cost of structural work, and whether or not under the terms of the leases that they had with the City of London, which were also right by leases. So in terms of so it concerns structural defects, and in terms of the case is at page 134 of the authorities bundle, and paragraph 18 at page 140. This is the Upper Tribunal, Mr. Justice Fancourt, says the relevant background to the individual leases is the statutory right to buy provisions first contained in the Housing Act 1980, then subsequently amended, then consolidated in the Housing Act 1985, and then further amended by the Housing and Planning Act 1986. The form of lease prepared by the solicitor to the corporation was self-evidently intended to comply with the statutory requirements for right to buy long leases, namely that the lease must comply with parts 1 and 3 of Schedule 2 to the 1980 Act. It is important, therefore, to understand the terms of the relevant parts of the legislation with which the leases were intended to comply. Neither side in this dispute contends that any other factual circumstances surrounding the grant of the leases are material. So this comes back to the point I was making. The leases in this case were granted between 1983 and 2015. So it wasn't the case that the leases were subject to the provisions of the Housing Act 1980. It wasn't the case that at the date of the grant of the lease, the relevant legislation was that Housing Act 1980. But what was found was that it was clearly intended that these leases should be drafted to comply with those provisions. And that was confirmed in the same case in the Court of Appeal. And so the Court of Appeal decision appears in the authorities bundle at 146 and at 151 in this court. Lord Justice Lewison says it's common ground that the legal background is relevant to the interpretation of the definition. I begin with the common law. He then goes on over the page at 152 at paragraph 13 to say, because the leases were granted pursuant to the right to buy, the legislative background is also an aid to interpretation of the covenants. At the time when the first of the leases was granted, the relevant legislation was contained in the Housing Act 1980. Despite changes in the legislation, the leases have remained in the same form throughout. It is not suggested that leases granted later in time should be interpreted differently from those granted earlier in time. And that goes back to the point we're discussing in terms of how you look at the later leases. Now, there is a slight difference in our case because the leases granted later in time from 1995 onwards are different, but they are only different to the extent that they simply delete that carve out. They don't, we say, materially alter the meaning of the rest of the lease. And I'll come on to the effect of the carve out and the effect of removing it and why that reflects. But just to bear that point in mind, which it goes back to about looking at these later leases by reference to the earlier leases, not because the leases themselves were part of the factual matrix, but because all of them were granted to comply with this earlier legislation.
So have I understood correctly that you're not saying that the cost of making good structural repairs couldn't have been passed on to the tenants? You're saying that if it was intended to do so, you would expect explicit language equivalent to what we have for repair and maintenance.
Yes.
Is that your position?
Yes. Yeah. You also then have, again in this court, the very recent decision of Plymouth and Crisplain. Should point out, despite the date on this, I could not find that it had been reported before finalising the skeleton argument, which is why it didn't make it in. I was aware via social media it had happened, but I couldn't find any actual report. It simply provides another example in terms of the relevance of the statutory scheme, in that this is a decision of Lord Justice Nugee. Sorry, the case itself appears at 179 of the authorities bundle. It is concerned with repairing roofs. At paragraphs 11 and 12 at page 182, it refers to, at this point, one must refer to the provisions of the Act under which the lease was granted. And I'll come back to what the actual facts, but as I say, at this point, I was just wanting to highlight that the judge dismissed even looking at the right to buy legislation as an aid to construction. And what these cases show is that that was, in my submission, wrong. So having looked at the fact that the right to buy legislation is relevant, I will try and explain more clearly than I managed to the Upper Tribunal the history of the Housing Acts and what that means in terms of these particular leases. As my learned junior says, it's a bit of a fiddly argument to elaborate, but it might be helpful in considering it to bear in mind a Venn diagram where we've got repairs in one circle. We've got works to remedy a structural defect in our second circle. And there is an overlap in the middle of the Venn diagram, which are repairs which make good a structural defect. And as Mr. Bates said, the case law establishes that there is that middle category of repairs that make good a structural defect. And what we're saying, aside from the very general point that there is this implied obligation, why isn't it dealt with explicitly if it's there? What we're saying is that there is the lease deals with one circle of the Venn diagram, which is the repairs. The lease deals with the first leases deal with the intersection of the overlap, repairs that amount to making structural defects. But what is absent entirely from the provisions of the lease is the remainder of that circle, the making good of structural defects. And I think that's an important sort of visual to have in mind as we look at how the Housing Act treated those different elements.
It's the point of disentanglement that in the part of the circle that's just dealing with what you've described as structural defects.
Yeah.
By that you mean structural defects which do not give rise to a deterioration in the condition of the
Yes.
property.
Yes. So the putting right of those
Can't be a repair.
cannot be repair.
Yeah.
And as was found in the Upper Tribunal, it's not maintenance or keeping in good condition, because what's said and what the case law on that was found to say was essentially maintenance might be something different. It might be preserving a functional character, but it is about preserving something in a state that it has previously been. And so what you're doing is remedying structural defects which effectively give back a building that wasn't as it was in the first instance, that does not fall within your covenant to maintain or your covenant to repair.
Why does it need to include that last clause about not giving back a building like the one you had before? Why can't you have an inherent or latent defect?
Sorry, yes, I perhaps went too far. Yes,
in
there is
the design of the building, which requires works to be undertaken, but
Yep.
but that latent defect has not manifested itself in
Yes.
any deterioration
Yes.
in the condition of the building, of the fabric of the building.
Yes, yes. So that is the bit of the Venn diagram that, as I say, is not covered by the lease, but the Housing Acts look at the whole of the Venn diagram and how the implied terms and what can be recovered.
Can I just, so if I've kept up with your Venn diagram, I think I understand your three circles.
2 circles, 1 intersection.
2 circles, 1 intersection. That's right, 3 bits. One is repair. The other one is repair to remedy a structural defect.
No, 1 circle is repair, 1 is remedying a structural defect. In the middle of the Venn diagram where there's an overlap are repairs that remedy structural defects.
Right, okay, sorry, I thought, okay, yeah.
So that there's an
All right,
over
The structural defects which have given rise
to a need to repair.
to a deterioration in the fabric of the building.
Or deterioration which constitutes a structural defect, i.e. water ingress which weakens
Yes,
some concrete fitting.
yes,
Right.
yes. In the context of the,
Sorry, this wasn't actually so I was going to get onto the question without getting. I thought you said a moment ago when you were trying to introduce this that the lease doesn't distinguish between all 3. Or I mean, the lease deals with all 3 of your areas, both the 2 circles and the oval. Doesn't it?
no,
Does it not?
no. So what the lease, and so I'll say, if I try and explain the background and then we can look at that relative to the lease. But as Mr. Bates was explaining this morning, what the lease refers to is repairs that amount to the making good of a structural
Yes,
defect.
but it also refers to just the making good of structural defects.
If that was the case, I don't think we'd be here. Where, my lord?
Okay, go to page 44. Second line. Page the lease, fifth schedule. So what is what I was asking Mr. Bates about? It's the
Insurance.
and also insuring against the making good of structural defects.
Yes, but that also refers to the repairs. So
Okay, you're going to have to help me with the syntax of this, just in the same way as I asked Mr. Bates to, because at least on the face of it, at the moment, I'm struggling to see that as necessarily just dealing with the repairs which amount to the making good of structural defects. It just talks about insuring against the making good of structural defects. It doesn't say insuring against repairs which amount to the making good of structural defects, which it has done twice in the previous bit of the clause.
yes, sorry, I was looking further up at the carve out, which
The carve out twice refers to repairs as amount to the making good of structural defects.
yes, so it refers.
But then it goes on to deal with something which seems to be on the face of it different, i.e. the making good of structural defects, with nothing to do with repairs. And this was the point I was trying to put to Mr. Bates, probably very badly. If the lease deals specifically with the possibility of insurance against the making good of structural defects, where does that take us? I'll just leave it neutral hanging, but it was your comment that the lease doesn't seem to deal with all three of your Venn diagram areas. And on the face of it, it deals with repairs elsewhere, clearly. It deals with repairs amounting to the making good of structural defects. And on, just at least on my view of that wording, it also deals in the context of insurance against just simply the making good of structural defects. So I thought the lease did deal, at least in some parts, with all three areas.
Well, although I think the point you were making this morning, if perhaps I misunderstood, was that it seems to pass on the cost of insuring against making good structural defects without explicitly referring to the cost of making good the structural defects.
Correct.
And that also I think the point was being made that if the tenant is paying to insure against the making of structural defects, you wouldn't then expect the tenant to be making a payment in respect of. And so
correct. Because it would be for the landlord to insure, to take out the insurance against structural defects in the building, and he can pass on the premiums for doing so to the tenants. What he can't do is simply to pass on the cost of making good the structural defects.
yes, and
That's the point I was trying to make, but I was only picking you up because you seemed to be saying that the lease didn't distinguish between, didn't identify all three of your areas in your Venn diagram, and I was just trying to point out that I thought it did.
and apologies, yes, it deals with the cost of insuring, which in that respect possibly not outwith the statutory purpose when we're looking at sort of what costs the tenants might be liable to meet. And it's not in terms of being consistent with that. The liability to pay for repairing structural defects is likely to be significantly more, one would have thought, than the cost of insuring if the landlord chooses to do that against those sorts of costs in terms of insuring against structural defects. But we'll come on to look at, if I may, the actual what the Housing Act say in relation to those. But I just thought it was important to bear in mind at the outset, because this morning it seemed to Mr. Bates did eventually get to the point of highlighting that it was repairs that amount to in the carve out, but it's important, I think, to bear in mind those categories as we go through. So we, as I say, the Great Arthur House, and particularly in this court, is a very useful example of how the legislative background has been applied. And we do, as Mr. Bates referred to, have the various statutory provisions. But if I may, I'll take you to Payne and Barnett, which Mr. Bates touched on. But I find that that's got a very helpful narrative explanation of the history of the Acts. So we've got, that appears at page 20. The judgment begins at 23. So at the bottom of 23, and you'll see that this was a case concerning flats within a building that had been constructed using the large panel system. It wasn't a case about service charges. The issue, trying to put it shortly, was the extent to which Mr. Payne ought to have been told by Barnet about the issues arising with large panel systems when he bought his flat under the right to buy. But Lord Justice Brooks starts at page 25. And it's towards the bottom of page 25, where he says, for reasons which will become apparent, we must now set out in rather greater detail the evolution between 1980 and 1986 of the new statutory code, which was concerned with issues connected with external repairs and the making good of structural defects. He refers to the fact there was originally no need for the landlord to say anything about service charges, repairs or structural defects. But in 1984, Parliament enlarged the scope of the notice. Over the page, he is setting out firstly what the notice needed to say about service charges, which he says at the bottom of the first paragraph over the page, internal page 301, bundle page 26, that in this judgment we'll use the expression normal service charges as meaning all these charges other than those attributable to repairs. He then goes on to say, this time it was Part 3 of Schedule 2 to the 1980 Act as amended, which set out the terms of any lease which might be granted under these provisions. Paragraph 13(1)(a) of this schedule imposed on the landlord, A, an implied covenant to keep in repair the structure and exterior of the dwelling house and of the building in which it is situated, and to make good any defect affecting that structure. So there were two elements to that part of the implied covenant. There's then an implied covenant in B, which is about other property. Just pausing there, if I could skip forward to the decision in this court in Great Arthur House, and that is at page 154. Do keep your finger in Payne and Barnet, please. But this is, at this point, paragraph 28, so towards the bottom of the page, the final paragraph, he refers to what Lord Justice Brooke was saying and says, Lord Justice Brooke was discussing the extent of the landlord's obligation, not the extent of the tenant's obligation to contribute. The landlord's implied covenant has two separate limbs joined by the word and. In that context, the way in which paragraph 13 was drafted made it clear that not only was the landlord responsible for repairs where there had been damage to the subject matter of the covenant, but also for making good structural defects even where they had not caused damage. Hence the draftsman's use of the phrase keep in repair in limb 1 and make good in limb 2. Limb 2 also refers to the making good of a defect, not to making good damage. He then goes on to mention Brooke and Post Office, which Mr. Bates touched on this morning. Going back to Payne and Lord Justice Brooke's exposition, and at 26 where we were, so he set out the implied covenant at 13(1)(a), and then he says at the bottom, we'll call the repairs referred to in these two paragraphs ordinary external repairs as distinct from making good structural defects. We make this distinction because it appears to us that the draftsman of the schedule is well aware of the vexed problem in landlord and tenant law of distinguishing between a liability to repair and a liability to make good an inherent defect. At the bottom of that paragraph where it's sidelined, in the Housing Act scheme, the landlord is fixed not only with the liability to keep the dwelling house structure and exterior repair, but also the liability to make good any defect affecting the structure. However, the requirements he must fulfil if he is able to pass on to the tenant any of the expense he may incur in meeting these liabilities is different in each case. This is evident from a perusal of paragraphs 15 to 17 of that schedule after the 1984 Act amendments. And it's there set out the various paragraphs, which I will come on to in a moment. But then if we go over the page, internal page 302, bundle page 27, this is what Mr. my learned friend Space was referring to, that at this stage of the Act's evolution, Parliament was making provision for normal service charges, ordinary external repairs, including repairs to the structure, and making good of structural defects in 3 different ways. And so it was the making good of the structural defects in C, that if the landlord wished to pass on to the tenant any part of the cost of making good a structural defect, of which he had become aware at any time earlier than 10 years, he could only require the tenant to bear the costs if he informed the tenant of the relevant defects and the estimate of the amount. So that's the notice requirement to be able to recover those. Lord Justice Brooke goes on to say these provisions were consolidated in section 125 and schedule 6 of the Housing Act 1985, which converted the former paragraph 17 of schedule 2 into a new paragraph 18 of schedule 6 in a slightly different form. So just pausing there, the paragraphs appear 15 to 17 of the Housing Act 1980 appear at page 189 of the authorities bundle.
Sorry, can I have that page again?
189. In fact, if one looks up, at 188, we have the implied covenant that was being talked about at 13.1a, which is the repairing and making good. Then we have at paragraph 15 at 189, the avoidance provisions, which is any provision of the lease or any agreement collateral to it shall be void insofar as it purports to, and then to enable the landlord to recover from the tenant, this is at B, any part of the costs incurred by the landlord in discharging or insuring against his obligations under paragraph 13.1a. So that is referring back to the implied obligation. So the starting point is the lease is void if the tenant is to pay any of the costs of discharging those implied obligations. But this is subject to section 19 and paragraph 16, and 19 is simply a definitional section about service charge, but 16, a provision is not void by virtue of paragraph 15 if it requires the tenant to pay a reasonable part of the costs of carrying out repairs not amounting to the making good of structural defects. So we've here got the wording that we see in our carve out, or the converse wording, or of the costs of making good structural defects falling within paragraph 17. So we've got repair, so there can be a liability for repairs not amounting to the making good of structural defects, that we can have provisions in there and they won't be void. But in relation to the costs of making good structural defects, they have to fall within paragraph 17. And the structural defects fall within that paragraph if the landlord has notified the tenant of them, or the landlord does not become aware of it earlier than 10 years after the lease is granted.
Can I just check that I've understood either where you are or where you're going with this correctly, so you can put me right if I'm misunderstanding. If we were to be against you on the construction of the lease, as I understand it, you're not saying that the legislation would render any provision void. What you are saying is that these provisions are relevant to enable us to reach the conclusion that clause 550 in particular does not extend to making good structural defects.
Yes.
Is that correct?
Yes.
Thank you very much.
So that's how it feeds into Lord Justice Brooke saying there was three separate methods: one for the ordinary service charges, 2 for repairs that did not amount to structural defects, and 3 for structural defects. And there were different ways in which they could be passed on. And in relation to those structural defects, they could only be passed on if there was notice or if there was a lack of knowledge, in short. And as he says, these were consolidated in the 1985 Act, and we have the original paragraph 18, which starts at page 232 of the authorities bundle. And so it's at the bottom of, actually, if we look briefly,
I mean, reducing your submission to perhaps too simplistic a level, essentially you're saying that this legislation is full of provisions about making good structural defects, which are conspicuous by their absence in the lease.
That is the simpler point, and that is point one. But point two is when we look at the carve out uses the language of what was paragraph 17 and what became paragraph 18.3, which is the converse of, it uses the language of the paragraphs together in terms of when it talks about repairs amounting to structural defects, because what it is referring to is those works that fall within the middle of the Venn diagram. So if I can, I'll come back to that point if I may, having gone through what happened in paragraph 18. And so there's a very simple point, but then there is the more technical point about why the carve out suggests that simply making good structural defects was not the intention of passing on the cost of that was not in the mind of the draftsman in terms of this lease. So, and I'll try and explain, as I say, where that argument comes from. That at 231 we have paragraph 14, which simply repeats the implied covenant, which there is at 14.2a, which is again the keep in repair and to make good any defect affecting the structure. We then go on, as say, to 232. We've got the avoidance, and again at 17.1, that the provision shall be, sorry, that was the wrong one. It's all consolidated now in 18, which is 18.1 is it's void if you allow the landlord to recover the costs of complying with that covenant, unless, and that comes in now at 18.2, it's a reasonable cost of carrying out repairs not amounting to the making good of structural defects. So that was fine. You didn't need to have any special provisions if it didn't amount to the making good of structural defects. And now we've got at 3, which is the old paragraph 17, which is a provision is not void insofar as it requires a tenant to bear a reasonable part of costs incurred in respect of a structural defect. A, we've got the notice period, and B, we've got the knowledge period as well there. So there's still, in effect, as Lord Justice Brooks says, it's effectively the same provisions that have been consolidated into one paragraph 18, as opposed to paragraphs 15 to 17 in the 1980 Act. It is obviously accepted that the Housing and Planning Act made further changes. And sorry, just jumping back to Lord Justice Brooks, he then refers to that after the part we've just looked at about the 3 different types of passing on the cost and the consolidation. He then says, in the Housing and Planning Act 1986, Parliament made further changes in this statutory scheme. And effectively, the conclusion is over the page at 28, which, again, the sidelined part, the effects of these amendments so far as they related to external repairs of the making good and structural defects was therefore as follows. And then under making good structural defects, the notice now had to contain a description of the structural defects. Subject to this, the landlord's ability to recover any part of the expense he incurred for making good such defects during the reference period was governed by the same principles as governed his ability to recover the cost of ordinary external repairs. So in other words, these provisions about notice and about knowledge periods effectively fell away by the 1986 Act, which came into force in January of 1987. So looking at our leases, and the first two leases in that schedule of 7 Malting and 44 Brewster. Looking at the history of the Housing Acts, it looks as if those leases have been intended to comply with the Housing Act 1985 before any amendment was made by the Housing and Planning Act 1986, because the carve-out is specifically referring to that notice period and the knowledge period. And so the language that's being used there is effectively the converse of repairs not amounting to. It's talking about repairs that amount to. And as I say, it's reflecting in the ways in which repairs that amount to structural defects, so the middle of that Venn diagram, because they are nonetheless works to make good structural defects, the only way they can be passed on is if those requirements are met, which is what the carve-out reflects. Just to say, I know that our leases refer to a period of 5 years, and the provisions that we're looking at refer to a period of 10 years. In the Upper Tribunal in Great Arthur House, Mr Justice Fancourt at page 141 of the authorities bundle, paragraph 25 of the decision, it's over the page, at the end of paragraph 25, so over the page at 142, top of 142, he's talking about these particular provisions and saying that there was 2 categories that were exempt. Repairs not amounting to the making good of structural defect, cost incurred in respect of structural defect, that was either notified to the tenant upon the grant of the lease, or of which the landlord became aware more than 10 years. And then in brackets he says, or 5 years, as it later became after grant. I have to admit, I cannot find where the 10 years was amended to the 5 years. I mean, Mr Bates says this carve-out is an amalgamation because the initial period became 5, but it simply doesn't reflect overall the changes that were made by the Housing and Planning Act 1986. It does reflect those provisions of the 85 Act, albeit the period is 5 years and not 10 years. So that's why I say that those 2 leases appear to be drafted in compliance with the 85 Act. And looking at what that means, if we look at the Court of Appeal, this court's decision in Great Arthur House, which they say starts at 146, the judgment begins at 149. And just pausing there at paragraph 2 on 149, it does refer to the fact that the leases with which we are concerned were granted between 1983 and 2015. It then goes on to set out the clause which was to be interpreted, and it was at the bottom there, the expression specified repairs, so this is what the tenants had to pay, is defined by the leases as meaning repairs carried out in order, 1, to keep in repair the structure and exterior of the premises and of the building in which they're situated, not amounting to the making good of structural defects. It then goes on at 2 to say to make good any structural defect of whose existence the corporation has notified the tenant, etc. So reflecting there the language again, and what was said by Lord Justice Lewison was that these were leases granted to comply with the 1980 Act, but as we've seen, there wasn't much material difference between the 1980 Act and the 1985 Act, other than the consolidation of the paragraphs. So moving on, and as I've said, at page 151, paragraph 9, he considers the background, starting with the common law background. At 152, he then goes on to look at the legislative background. at paragraph 13, and again I've referred to that about how the leases were granted later in time, but still fall to be construed against the backdrop of the Housing Act 1980. Then going on at paragraph 25, sorry, paragraph 22, which is at page 153, where he refers to the fact that these provisions have been through various iterations, some of which have modified them, but not so as to affect the issue arising on this appeal, but the statutory scheme was significantly modified by the Housing and Planning Act 1986. Moving on from there, going to paragraph 25, at the top of page 154, it is nevertheless clear that the immediate legal background to paras 1 and 2 of the definition of specified repairs in the leases was paragraphs 16 and 17 of the Housing Act 1980. He then goes on at paragraph 28 to refer to I've already referred you to the top part of paragraph 28, but at the bottom of that page, on page 154, I do not consider that, and this is Lord Justice Brooke, intended to cast any doubt on the cited passage in Woodfall, which stated in terms that works could be works of repair, even though their effect was to eradicate an inherent or structural defect. So they're referring to that middle bit of our diagram. That was explained more fully in Great Arthur House in the Upper Tribunal. So just keeping a finger in there and turning up page 141 of the authorities bundle. And there at paragraph 23, Mr. Justice Fancourt was saying, it might therefore have been thought that the categories of repairs and works to make good any defect affecting the structure were mutually exclusive. However, paragraph 16 shows that this distinction was not applied in relation to charging the cost of works. This paragraph deals with two categories of works in respect of which the lease may provide for the landlord to recover from the tenant part of the costs incurred. Repairs not amounting to the making good of structural defects and making good any structural defects falling within para 17. If for the purpose of charging the two categories had been mutually exclusive, the words not amounting to making good structural defects would have been surplusage. This provision therefore accurately reflects the state of the law, in which works that have the effect of making good a structural defect can nevertheless be repairs. So going back to Lord Justice Lewison at paragraph 36 of this court's decision, which is at page 156. And he refers there to the definition of specified repairs in the lease, to a large extent follows the provisions of part 1 of the the definition of specified repairs in the lease to a large extent follows the statutory provisions. Part 1 of the definition tracks paragraph 16, paragraph 2 tracks paragraph 17, which is the point I was making in terms of looking at them. But going back, as say, to that explanation in the Upper Tribunal, which again is set out a bit more fully, page 142. And at paragraphs 27 here, it said, against that background, it's clear that the terminology of the lease is to a large extent intended to mirror the underlying statutory provisions. The lease defines those specified repairs to which the lessee must contribute. Given the provenance of the terms used and the fact that specified repairs are described generically as repairs, the parties agree that the lease does not draw a clear division between repairs on the one hand and the making good of structural defects on the other. The wording of the definition contemplates that works may be done to the structure and exterior which are properly characterised as repair and which also amount to the making good of structural defects. And he refers to that work being in the overlap category. If we go on to paragraph 34 in relation to the Upper Tribunal, and it said there, Mr. Straker accepts the wording starting not amounting to operate by way of an exception or proviso to what has gone before. One would expect the language of the exception to define what is excluded. What is excluded is repairs that amount to the making good of structural defects. So the wording that we have in our carve-out. The natural reading of these words is that they are works which in law are properly characterised as repairs, but which amount to the making good of a structural defect. So we have here, and I appreciate this is the Upper Tribunal saying that is what those words in our lease, in our carve-out say. Going back, apologies for jumping around, to Lord Justice Lewison at page 156 of the bundle. And he goes on to say what the effect of the interpretation is, because he says at 36, and this is the bottom of 36, in one respect, however, the scope of the service charge is narrower than that which the statutory scheme allows. That is because the whole of the definition is prefaced by the words repairs in order to. It follows, therefore, that unless works qualify as repairs both under the fact and degree test and under the test that the works are carried out in order to repair deterioration or damage, they are outside the scope of the service charge. And at 38, he sets out that may well mean that the cost of some works that are within the landlord's obligation to make good structural defects cannot be passed on to the lessees, but that is a consequence of the way in which the definition is drafted. And there is no presumption that the costs of all works that the landlord is obliged to carry out can be passed on to the lessees. My Lord Mills, that comes back to your point that the cost could have been passed on under the statutory scheme if the explicit provision had been made. But, and actually, perhaps just looking then, because mindful of the time, so I'll very briefly mention Crisp Lane, which goes through a similar exercise. And that's the decision of this court, which is at 179, and that, to say, is talking about the roofs. And one of the things, what the whole point of that is, there is in that case, there was no obligation to pay for the work done to the roof. So there was no obligation on the landlord to, in the contractual machinery, to do the work, which would have meant the tenant was liable to pay for that work. But it was accepted that the statutory scheme implied an obligation on the landlord to do work to the roof. It was simply that the leases were drafted on the basis that the tenant wouldn't be liable to pay for that work. And so a similar conclusion was reached, that notwithstanding there might be an implied obligation, the leases were drafted that the landlord wouldn't get full recovery in terms of the cost of carrying out work that it was otherwise required to do. But looking at our leases, then where we have at page 43 our carve out, and as I say, that carve out, so what this carve out is doing is we've got the obligation, so it starts with the total expenditure, and that's the tenant leaseholder is liable to pay a proportion of that. Is the cost to the landlord of carrying out the obligations under clause 5.5. So we start from that proposition. So what is included in 5.5? Well, we know that it contains an obligation to repair and to maintain. Now, in terms of repairs, which amount to the making good of structural defects, and we've got that definition of what that means in the Upper Tribunal in Great Arthur House. So those are the works that fall within the middle of our Venn diagram. And the problem in terms of making the tenant liable for all repairs is that as regards those in the middle of the Venn diagram, the provision making the tenant liable would be void on the face of it in accordance with the 1980 Act and the 1985 Act, because it would be void unless the landlord has given notice, or unless the landlord doesn't become aware of it within a certain time. So simply in 1980, 1985, leaving paragraph 1.1 as it was without that caveat would have led to any repairs, the lease being void so far as they purported to provide for the payment of the landlord's costs of repairs which amounted to making good a structural defect. So that's why that carve out is in there, to say that those repairs, those type of repairs that amount to making good of structural defects, can only be passed on if we've given you notice or if there is no knowledge for a certain period. So that's why the carve out exists, to reflect the specific requirements that were needed to be met for the landlord to recover those costs. And as I say, otherwise the lease was void. Now, if the effect of paragraph 550, as the appellants contend, is that the cost of making good structural defects that do not amount to repairs, making repairs that do, structural defects that aren't repairs, so the bit of the Venn diagram that's not on the other side of the circle, if the lease were to make the tenant liable for those costs, then under the provisions of the Housing Act 1980 and 1985, those provisions would be void, because the carve-out is silent as to what happens to that wider category of works to remedy a structural defect. So the carve-out only applies to repairs that amount to making good structural defects, not the wider category of making good structural defects. And why is that? We say because the draftsman can't have intended that those works would fall upon the service charge, would fall to be paid in the first instance. There was no need for a carve-out to be any wider because it wasn't anticipated that those costs would be being recovered. So we've got that, and then if I can very briefly, just the reference to in Great Arthur House in this court, that at page 157, where we were a moment ago, but going down to paragraph 41, where Lord Justice Lewison says at the bottom there of page 157, if and to the extent that Mr. Straker's interpretation goes further than, I think he means paragraph 16, the Housing Act, the service charge...
Sorry, I've lost where you are.
Sorry, bottom of page 157 in the authorities bundle.
Yeah.
And it's the bottom of the paragraph where Lord Justice Lewison says, if and to the extent that Mr. Straker's interpretation goes further than 16, the service charge provision would have been to that extent void. It is well established that if there are two realistic interpretations of a contractual provision, one of which means that the provision is invalid and the other of which means that the provision is valid, the court should adopt the interpretation that results in the validity of the contractual provision. And then the application of that principle to this case means, in my judgment, that we should interpret the lease so that it conforms with the applicable legislative scheme. So that's the point I'm making, that in terms of, I appreciate that the leases were granted at a later date than the Housing Act 1985, but if we assume that they're granted to comply with the Housing Act 1985 before any amendments were made, then looking at it through that lens, imagining we're in 1985, it would have been void if it allowed for the recovery of the costs of making good structural defects, if those defects had not been notified, and we know that no defects were notified, or they were defects that the landlord became in terms of the date of the landlord's knowledge, so they had to come at a later date. So that is, in terms of why we say there's the very general point that if there is an implied obligation on the landlord to remedy structural defects, if there had been an intention that the cost of that should be met by leaseholders, explicit reference would have been made. But there is the more complicated or fiddly point that looking at the carve out, given the fact that it only refers to repairs to make good structural defects and not making good structural defects more generally, would suggest that it was not the intention that the cost of doing that was recoverable. And if the lease were to be interpreted differently, it would be to a certain extent void, as in 1985, which leans against, again, that construction. So that's why we say looking at those two leases earlier in time, that very much seems to be the intention. Then when we look at the leases later in time, the first point remains. There is still the implied obligation in terms of structural defects, making good structural defects, and it's not referred to. But what we say is simply removing that carve out does not alter the meaning of the clause in which it sits, let alone the wider lease provisions. So if the wider lease provisions are to be interpreted in the 1989 lease and the 1990 lease as meaning that there was no liability to pay for the making good of structural defects, we say simply removing that carve out does not affect that interpretation. And what we then say is just the reason...
How would the contracting part, what assumption can you make about whether the contracting parties to the later leases knew anything at all about the earlier leases?
I haven't, as I say, I don't think we can say that, but looking at I'm looking perhaps more widely at the drafting of the lease and the intention of the draftsman in drafting the lease, and we've got, say, the same lease there. So it's in terms of the way in which the lease, which is very much the approach which was taken in Great Arthur, is what the draftsman was doing in terms of this lease. And then, as I say, simply removing, and it was removed because when we get to the 1986 amendments, there was no need for those separate requirements in terms of recovering the cost. So there was no need of the carve out. And what seems to have happened, Tower Hamlets seem to be a bit behind in doing it, but at some point they've come to update their leases and said, well, hang on a sec, we don't need this bit in, we're pulling it out. So I appreciate that's not necessarily looking at what the parties at that stage intended, but it's looking at the manner in which this lease was drafted and the intention of the draftsman to the lease and the manner in which that was done.
I mean, you don't need to impute any knowledge about the terms of the previous lease to the parties to the later lease, do you?
No, I don't.
You simply make the same points that you have been making to us at the earlier stage of your argument. That's to say that the legislation, and we take account of the legislative background, you say, refers to making good structural defects, and the new lease doesn't.
Yes.
That's how that's.
Well, as I say, that in terms of those earlier leases, there were two points, but sort of allied, which is it stems from the implied obligation to make good structural defects, and that isn't specifically referred to as, say, those earlier leases go further because they refer to that carve out. The later ones,
your as it were, your more complicated point, as you described it, I think, which depends on interpreting the carve out as dealing with repairs which make good structural defects, simply falls away in relation to the later leases, doesn't it?
If one were to look, I accept if one were to look at the later leases in isolation, it does. As I say, looking at the background and the original drafting of these leases. So I mean, I can't.
Well, I think the buyers are not going to know anything
that.
about the previous terms.
No.
It may be that there is imputed to them, as a matter of law, the legislative background or some aspects of it, but they don't know anything about.
Yes, I don't think I can press the point any further.
Can I just add one observation then on that? I mean, it's of course right that you can't assume that without some evidence that later people know about the previous leases, except if you go to page 986.
Of the core bundle?
Supplemental.
Supplemental bundle.
900 and...
Printed 986. This is a point that I had in another service charge case.
Oh, yes.
If you look at sub-clause 5.2, where there is in these leases an obligation, a covenant by the lessor that every lease or tenancy in the flat in the building contains regulations to be observed upon the lessee, and that would include payment of service charge, in the similar terms as contained in the 4th schedule, and covenants of a similar nature contained in clause 4 of this lease. And there's the same provision at page 30 of the earlier leases in relation to tenancies both hereto before or hereafter granted. The assumption in all these service charge cases of flats in blocks is that there's a similarity of operation of service charges, because otherwise you get the problem that certain people pay certain service charges and other people don't. That is a legitimate aid to interpretation because it's a clause of the agreement.
Yes. Thank you. I'll take that one. I was going to, that was my explanation in terms of looking, which rather longer than I anticipated, but looking at the legislative background, the statutory framework, looking at the background against which the leases were drafted as an aid to construction. The other relevance, I say, of the right to buy provisions is the statutory purpose. And as I say, that's a relatively short point. That's dealt with in Great Arthur House in the Court of Appeal, and that appears at page thank you. Oh, that's where I got confused. Paragraph 50, which is at page 159, where Lord Justice Lewison says, "Nor do I consider that the interpretation that the Upper Tribunal adopted is in any way contrary to the legislative purpose of the right to buy. The purpose of the legislation was to encourage home ownership by council tenants, often persons of modest means. That was achieved not only by giving them the right to buy at all, but allowing them to buy at a substantial discount from market value. Although it is true, as Mr. Traker said in his skeleton argument, that many people were attracted by the investment value of such acquisitions, the legislation deterred quick turnover by providing for clawback of the discount in the case of early sales. It's long been the common law that, except in the case of a sale of a lease by a builder in the dwelling in course of construction, the seller or lessor gives no implied warranty that the dwelling has been properly constructed, or indeed that it is fit for habitation. But it is by no means surprising that Parliament gave a measure of consumer protection to persons to whom the right to buy was given, by partially insulating them from liability to contribute towards the cost of rectifying structural defects in the property in question. The case is all the stronger in a case of the building like Great Arthur House, because it cannot be supposed that the purchaser of a single flat in a large block would commission a structural survey of the whole building before committing himself to acquiring a long lease. So what we say is that the construction of these leases, so as not to make the tenants, leaseholders liable for the cost of remedying structural defects, is entirely consistent with that statutory purpose, that wider statutory purpose which would apply to all of them. So that deals with the background against which the lease is to be constructed. We then come on to the particular clauses in the light of how they have been looked at and interpreted. I am very mindful of the time.
Yes, how long are you going to be?
Well, I probably had intended to be longer than 5 minutes, but I can try and be rather quicker, because it's actually, in terms of this element of the case, we say that the learned judge was right for the reasons that she gave, and that the criticisms of her are entirely misplaced in terms of her approach to these particular covenants. So I can try and be a lot quicker. If your lordships are able to offer me anything more than 5 minutes, I would take it.
Yes, all right. Well, if you conclude in 5 minutes or just over, I think that is necessary, really, to give Mr. Bates a little bit of time to reply.
Thank you.
If it helps, I only have 3 points in reply so far.
And my lords, what time otherwise were you planning to sit until?
Well, we usually finished about 4:15. If we need to go on a few minutes beyond that, I dare say we can. But we need to finish quite soon after 4:15.
I appreciate, as do I. So in terms of the looking at the clauses generally, I will simply flag up the case of Holding and Management and Property Holding Investment Trust. That is also a decision of this court. It appears in the bundle, authorities bundle at page 3. The judgment begins at page 6. The covenant is set out at page 8. It is slightly different in form to what we are considering here, in that the relevant parts were to carry out repairs. So the very relevant bit was such other costs as the maintenance trustee shall consider necessary to maintain the building as a block of first-class residential flats or otherwise desirable in the general interest of the tenants. So no specific mention of safety, but general interests of the tenants. The work in issue was, again, quite extensive.
Why is that case of any real assistance? I mean, you've got to just deal full front on with the word safety, haven't you?
If my lord, I think the approach, what I would say in terms of the word safety is it is not a literalist approach. We are not simply saying that anything that is about making the building safe falls within that clause. If the landlord suddenly decides it wants to, I don't know, a prison-style perimeter fence around the building, which would make it safer, is that actually something the cost of which should be passed on to the long lease lessees under the covenant, under the covenant in 550? What we say is, and I'll focus then on Dell, that the approach that was adopted by this court in Dell to a clause that was in almost identical, well, pretty much identical terms to ours. It used the term general expenditure rather than total expenditure, but in both respects. It contained in 44L a similar covenant to that in 550, and it contained in the relevant schedule, as I say, to a definition that was in like terms to the definition that we have in paragraph 1.1. And what we say is that the judge in the Upper Tribunal here did not fall into error in treating Dell as being authority for any particular principle, but the judge in our case had been the judge in the Upper Tribunal in Dell. She approached the interpretation in the same way. This court approved her approach to that interpretation, and so she embarked on the same method. That wasn't to say she accepted any principle. She did not put a quantum gloss. That was an argument that was rejected in this court in Dell, because what was said was that it wasn't about the fact that the costs were extensive in Dell. It was the nature of the costs that were the nature of what the landlord was trying to get within the covenant that made it fall out, and that it was relevant considering whether or not works of costs of that nature fell within the covenant to have reference to the fact that the likely scale could exceed anything else in the rest of the covenant. And similarly here, what the judge did was consider that works to make good a structural defect could be costs of carrying out works to make good a structural defect could be open-ended and could lead to potentially ruinous, is the word that is used throughout both judgments, which is that this is, if you'd have asked the tenants in signing up to this lease, would you be signing up to costs to create an external frame on this building? The answer would have been clearly no. But looking at the nature of the works rather than the value of the work, that making good structural defects is in effect can be an open-ended liability, similar to Dell, where the litigating with a neighbour over a planning dispute could be an open-ended liability. So there was no quantum gloss. It was looking at Lord Neuberger's 7 principles, the context in which the words appear, and so as in Dell, what happened in the Upper Tribunal was looking at where Clause 550 fell within Clause 55 as a whole, and the other items of service charge expenditure, which was said to inform what the sorts of things that would fall within 550. So those day-to-day routine sorts of costs. In terms of the purpose of the clause, that wasn't specifically referred to. The principle of looking at that was referred to in Dell. Lady Justice Falk didn't go further, but what she did, so looking at that in asset hold, to which my learned friend Mr. Bates referred, it does talk about it being a future proofing type clause, and that. And just going very briefly to asset hold, which I should say was distinguished in Dell, and it's a decision of the Upper Tribunal, but it does say, paragraph 59, page 131, a general provision such as para 6 is included in a lease precisely because the parties appreciate that they cannot anticipate all eventualities. And so the parties must be taken to expect that an agreement to last circumstances may arise which they do not specifically contemplate at the time of contracting. Now, just a point there, in terms of looking at a future-proofing clause, that is allied to the factual matrix, which Lady Justice Falk did deal with. And one of the things that she referred to was the fact that the potential for litigation in relation to this building must have been within the contemplation of the parties at the date they entered into the lease, because there was a restrictive covenant, it had already been litigated over, and that there was no express mention in relation to anything to do with that, how consent would be given under the covenant, for example. Now, similarly, looking at our case, the factual matrix clearly includes the fact that not only were the leases granted pursuant to the right to buy, and that contained the implied covenant, as we've discussed, to make good in structural defects, but also that these were LPS blocks that were known to be constructive in design. So in terms of looking at the factual matrix and the purpose of the clause, if the purpose is to guard against things that couldn't be anticipated, and the factual matrix is, well, all of these things could have been anticipated, it isn't likely that the making good of a structural defect would fall within the clause, interpreting it in that way. That's not operating as future-proofing because it was known that the landlord at the date of the grant of the lease had an obligation to remedy a structural defect. And further, in terms of these specific buildings, it was known that there might be issues. As I say, I think we've dealt with the context, which say similar to Dell, it was looking at it within the context, the purpose, the factual matrix, and then, as Lady Justice Falk said, commercial common sense could be used as a cross-check. And this is where it is said that the quantum gloss comes in, but it is quite clear in looking...
Ask you to pause for it. Why does it help you to say that at the time of the grant of the lease, it was known that these buildings were defective?
Well,
because wouldn't that suggest that the word safety, if taken out of context, could include remedying structural defects which make the building unsafe?
The point I'm making is that if that was a known feature, rather than having a general clause of the nature of 550, there would be a specific reference, rather than simply general safety, leaving those potential problems to be swept up, as it were. There would be a specific clause that would deal with that, and that's the point that was being made in Dell, was that it was known that there were likely to be problems, so that actually you would expect, if it was intended that dealing with those problems was to be something the costs of which the leaseholders should meet, you would expect specific reference to be made to that. So that in my submission, safety isn't enough to be specific about the issues that have arisen or were likely to arise in this case. As I say, the final point was that the commercial common sense, which effectively is that quantum gloss, which was looking at if the parties have agreed would the leaseholders have entered into a contract which made them liable for the type of costs that could be potentially ruinous, and that was the commercial common sense cross-check that was applied. That was Judge Cook applied in the Upper Tribunal in Dell. That the Court of Appeal in Dell agreed with that approach, agreed that she hadn't put a quantum gloss, and so she was very careful, we say in this case, to do the same. She didn't look at, it wasn't the cost of the works themselves that meant that they couldn't be recovered, but it was the nature of the work that was being done and the fact that that could lead to a very large liability that meant that those costs, the nature of those costs were not something that would have been within the contemplation of the parties in entering into the lease. I think just a final point, because there's obviously ground two, and it's sort of, there are two arguments made. What was said in the Upper Tribunal and what was said in Dell and what was said in the First Tier Tribunal in this case was that really the arguments under 550 and under paragraph 1.1 of the definition stand or fall together. But if the works are not within, if the liability to pay doesn't arise because of clause 550, then it seems even more unlikely that it would arise by virtue of definition section within a lease. I would commend the judgments both in Dell and in the Upper Tribunal in this case to you in terms of dealing with those clauses, but unless I can be of any assistance, those are my submissions.
Thank you very much. Yes, your 3 points, Mr. Bates.
And happily they remain 3. So, the first of my 3 points then, my learned friend put this to you in various different ways. At one stage she said that these are costs that leaseholders would never have agreed to sign up to. Then towards the end of her submission she asked rhetorically, did they sign up to paying for an external frame on this building? That's not the question. The question for the appeal is, what do the words in 550 objectively mean? And I ask rhetorically, why is this not work of safety? How do you exclude some safety works and not others? This isn't a literalism criticism that my learned friend makes of me. This is the proper process of construction. You start with the meaning of the words. Test it this way. Why else are these works being done? They're not being done for energy efficiency reasons, as is quite common in the case these days. Not being done to make it more beautiful. They're being done to make this building safe. And that's why they fall within 550. 2 points on the right to buy, because in my submission it's significantly more straightforward than my learned friend made it. She started by saying that the right to buy is relevant as part of the admissible background material. You construe the leases in light of their statutory background. I have no difficulty with that as far as it goes, but we need to be clear as to what that background is. Can we go in the authorities to page 213, which is paragraph 16A of Schedule 6, which we did look at this morning. This has been the relevant provision that governs how you charge for structural defects since the 1986 Act. And what it says in 16A1A is that the lease may require the tenant to bear a reasonable part of the costs incurred by the landlord in discharging or insuring against the obligations imposed by the covenants imposed by virtue of paragraph 14.2. And 14.2 is the implied repairing obligations and making good these structural defects. That's it. Since 1986, it's been a question of construction of the lease, whether or not you, as the draftsman, opted into this right to charge. All those cases about void and repairs relating to making good structural defects, that's all pre-1986 stuff. And the point of the 1986 change, as discussed in Barnett and Payne, was to cut through all that with a much more simplistic route. You have a 5-year transition window now, and otherwise you should look at the lease. Are you allowed to charge for it? And that's all this case comes down to. Are 550 or Schedule 5 paragraph 1 enough on the normal principles of contractual interpretation? If they are, the right to buy changes nothing. If they're not, the right to buy doesn't help me. And that then takes me to the third point. statutory purpose of the right to buy. My learned friend at one point said that it's no purpose of the right to buy to slap leaseholders with costs. I know she was being slightly tongue-in-cheek, but that's not a fair characterisation, as I'm sure you'll appreciate. Local authorities, indeed all public authorities, have duties in respect of public funds. If they can recover, they should. She took you to the Cabinet report in her submissions. At the time, it was looking like about £8 million worth of work, of which about £2 million would be recovered from leaseholders. That's £6 million that falls on the tenants to pay for, because remember, for local authority finances, you can't use your general fund to meet these costs. You have to meet your housing revenue account, your rents, effectively. So the question of statutory purpose, really, statutory policy, doesn't really take us anywhere here. There's a reason Lord Justice Lewison put it last in Great Arthur House. He'd worked out what the answer is and then said there's nothing inconsistent with policy to come to that. That's where policy comes into this question. And there's certainly no part of the policy of the right to buy to provide lasting subsidies in respect of works. Ultimately, this case comes back to the same question. What do those clauses mean? If they're apt to cover what we say they are, then a charge can be made. If not, then they can't. It is as simple as that. Just one final point, picking up on exchange my lord had with my learned friend. Although I haven't put my case this way, it seems to be pretty, at least plausible from the questions you put to my learned friend, that the court might take the view that there is a difference between the effect of the two leases, those with the carve-out and those without. I'd simply say I see the force of that argument. It's not my case. My case is you can read them the same way, but I'm not going to pretend I don't see the force of that. And there's nothing more I want to say about it. I appreciate it's not the case I've been making, but I don't think there's anything I need to say about it. It might give rise to different
If there was a material difference between the different leases in the block, that is not certainly what seems to have been envisaged by the leases themselves, because both new and old contain the very similar provision that says, so far as lessees' covenants are concerned, they're all going to be in materially the same.
But nonetheless, if that is what's happened, then that is what's happened. I'm not saying it's impossible to reach that conclusion. I've been submitting to you that the carve-out makes no difference, but I might be wrong about that. And if I am, I am. Unless I can help you with anything else.
Well, thank you very much. Thank you to both of you and those behind you as well. We will reserve our judgments. They will be sent to you in draft to those whose names have been provided to my clerk. That will be for the purpose of correcting any typographical or minor factual errors, and we hope and expect to enable you to agree to an order reflecting whatever it is that we decide. Until the drafts are formally handed down, they will be subject to the embargo, so that they can only be used for that limited purpose, and as I'm sure you're aware, the court takes that very seriously. We will then hand down our judgments by having them put on the National Archive. There won't be any need for any further attendance. If you can't agree the terms of an order, then we will have short submissions in writing, and we will deal with those also without a hearing. I think that is everything I need to say. So that concludes the appeal hearing. Thank you all very much.
Court rising, please.